كلية الفقه الحنفي تقدم.
Assalamu alaikum wa rahmatullahi wa barakatuh. My dear brothers and sisters, Allah subhanahu wa ta'ala bless you all. We have reached lesson number 14 from this semester on the judicial law in Islam. We've alhamdulillah covered many aspects. So we just finished off covering how different jurisdictions would work in terms of half the judicial process being undertaken in one area and then that being taken to another area. We discussed a number of these things and how the official correspondence would be and so on. Now we're in this next section. What we're dealing with is, let's just say that a full judgment of a judge has taken place somewhere, a full judgment has been given, and then that is presented to another judge somewhere else. A judgment of another judge is presented. What right does this second judge have? What right does he have with regards to that first judgment? Can he do anything about it? And what kind of scope is there? So that we're going to be dealing with that. Then also we're going to be dealing with al-qada'u ala al-ghaib, which essentially means we've already dealt with that a few times, but now he's actually going to cover it here, where he discusses judgment against somebody who's not present, right, an absent person. And then thirdly, the third discussion will be tahkimu rajulaini rajulan baynahuma. So this is where you have an informal arbitrator that two parties decide to appoint between them rather than go officially to a formal judge. So if that happens, what scope does this informal arbitrator have? How much can he judge in this kind of a context? What can he do, and what becomes binding, and what scope essentially does he have? So these are the kind of discussions that are still left. So inshallah we're going to be covering that inshallah in today's lesson, which is lesson number 14 inshallah. So having said that, we're going to say inshallah bismillah and begin. Allah bless you all. So bismillahir rahmanir rahim. Imam Quduri says, وَإِذَا رُفِعَ إِلَى الْقَاضِي حُكْمُ حَاكِمٍ. If any judgment of another judge is presented in front of another judge, right, مُوَلًّا وَلَوْ بَعْدَ عَزْلِهِ أَوْ مَوْتِ إِذَا كَانَ بَعْدَ دَعْوَى صَحِيحَةٍ. Now this could be that the judgment was of a judge who has now passed away, or he's been dismissed, he no longer is a judge anymore. It could be any of that situation. Mostly the reason for presenting a judgment of another judge would probably be to ratify it somehow, and maybe he died, or maybe he has, so amdahu, this judge, he has to, since the judgment was already made, he has to now continue it, meaning he has to implement it, he has to let it go, he can't cancel it. أي ألزم الحكم والعمل بمقتضاه. He will implement the judgment and whatever work has to be done based on it, سواء وافق رأيه أو خالفه إن إذا كان مجتهدا فيه. So now it depends on the judgment. If the judgment is regarding something that can have more than one opinion, some things are very clear cut, they are explicitly legislated in the Quran or the Sunnah, but then there's other things in which there could be more than one view. So let's just say there's a judgment that had been provided by a judge that had originally been appointed, or that is now appointed after he was maybe dismissed earlier, now he's been reappointed, for example, whatever the reason is for there to be another judgment. as long as the claim was correct, the lawsuit was valid, right? أمضاه, he will let it carry on, he will implement it. أي ألزم الحكم والعمل بمقتضاه, which I've already explained to you. سواء وافق رأيه وخالفه. This is the interesting part. Whether it conforms to his own opinion, whether that would have been what he had done, that would have been the judgment he had made, or whether it opposes the judgment he would have made. As long as the issue is with regards to something that is mujtahad fi, which means that is open to difference of opinion, that has a scope for difference of opinion. لأن القضاء متى لاقى محلا مجتهدا فيه ينفذ ولا يرده غيره. He can't cancel that, because he's saying that whenever a judgment, a proper judicial judgment, whenever it is regarding a case that is open to interpretation or various opinions, then once it's a judgment by the judge, it becomes ratified, it becomes strong, and it is implemented, and nobody else can repel that, cancel that out, reject it. لأن الاجتهاد الثاني كالاجتهاد الأول, because the first judge, whatever he did, as long as he followed the procedure, and it was obviously regarding something that could have more than one opinion in, then why should the second judge's opinion be superior to this judge? Because it's not about the judge himself, it's more about the process and how you reach an objective with that process, and you make a judgment. So once the judgment is made, it becomes nearly set in stone, in a sense, nearly set in stone. So the other person can't turn it back, he can't cancel it, because there's no preference for his over the other one, because this is a case in which you could have more than one opinion. So that's what he's saying. وَلَا يَرُدُّ غَيْرُ لِأَنَّ الْإِجْتِهَادَ الثَّانِي كَالْإِجْتِهَادِ الْأَوَّلِ. His ijtihad, this new judge's ijtihad, is just another ijtihad, just like the first person's ijtihad. Why is that better? He will think it's better, but in terms of the fact that this particular issue can have more than one interpretation, in terms of that, they're all equal, because they're both by qualified individuals, and they've all followed the procedure. لِتَسَاوِيهِمَا فِي الظَّنِّ. And because it's a ijtihadi issue, whatever each one of them saying is just conjecture, or it's speculative anyway, it's not definitive. Yes, each one will probably think that he may think that his opinion is more definitive, but since it's an issue that all other jurists would agree that can have more than one opinion in there, right? Moderate, decent jurists would agree, then ultimately each person's opinion is speculative. It's not definitive. It's never 100%, because nobody knows what exactly Allah's decision is with regards to that. وَقَدْ تَرَجَّحَ الْأَوَّلِ. Now already the first judge's judgment has become preponderant by the fact that a judgment was given on it. So his opinion, along with his judgment, has made that opinion superior already. It's stronger than the first one, because a judgment was given there in an Islamic court. فَلَا يُنْقَضُ بِمَا هُوَ دُونَهُ. So it can't be broken by something which is of a lesser degree, which is just the opinion of the second judge. So both the first judge and the second judge both had opinions, but the first one made a judgment based on his opinion, just because of the fact that he was first, right? I guess, right? So the second one can't cancel it. Now, if وَلَوْ قَضَى فِي الْمُجْتَهَدِ فِيهِ مُخَالِفًا لِرَأْيِهِ نَاسِيًا لِمَذْهَبِهِ نَفَذَ عِنْدَ أَبِي حَنِيفَةَ. If that first judge, or any judge for that matter, had produced a judgment regarding a case that could be open to and can have multiple opinion, a mujtahad fi issue, and the judgment he gave was actually against his own opinion in that regard, how does he do that? For example, he's a Hanafi, or he's a Shafi, he's a follower of a madhab. His madhab has, and he abides by his madhab. His madhab said one thing, but he made a judgment about something different to that by mistake. Nasiyan madhabahu, which means that he forgot what his opinion was, but he just remembered that, oh, it should be like this or like that, but it was actually a mistake. A mistake in the sense that it was still a valid opinion that he gave, meaning one of the possible valid opinions, but it wasn't his madhab's opinion, which means that that would have been his opinion, and he found out later, oh, Nafadha inda Abi Hanifa, Imam Abu Hanifa says that that would be implementable already, that would be applicable. وَإِنْ كَانَ عَامِدًا. However, if he did this on purpose, that his madhab says one thing but then he went against that, or his own opinion is one thing and he went against that for whatever reason, right? But again, it's a mujtahid fi issue, then there are two transmissions with regards to the status of this. According to the Sahibain, لا ينفذ في الوجهين. They don't agree with it being implemented even in the first case, which Imam Abu Hanifa allowed, that he had forgotten what his opinion should have been and he gave, a valid opinion, but it was not his opinion, and he made a mistake. Sahibain say that it wouldn't be valid in that case, nor would it be valid in the case of doing this purposely. That's more agreeable anyway. لأنه قضى بما هو خطأ عنده, because he's making a judgment based on what is a mistake, what is wrong, what is incorrect according to him. So how can that be a judgment if a judge is judging and producing a judgment that is on an opinion that's incorrect? وعليه الفتوى. So the fatwa is usually given on this view that none of these are going to be acceptable, whether he done it forgetting his opinion for that moment or whether he did it on purpose, as is mentioned in the Hidayah, the Wiqaya, the Majma' al-Bahrain and the Multaqa al-Abhur, etc. Now he says that قيدنا بالمولى لأن حكم المحكم لا يرفع الخلاف كما يأتي. We said that the judgment we're talking about is of a judge who has been officially appointed. If it's the one we're going to speak about soon, which is the one just appointed informally by two parties, individuals, and who's not officially appointed by the state, then obviously his judgments can be broken by official judgment somewhere else, because his is not an official judgment. It's only good enough for the two parties that have designated him as the arbitrator. It's not the state who's done that, so his judgment won't carry much weight for anybody else besides the people who have put him in that position. Okay, we also the Imam Maidani says that we also mentioned that such a judgment should have come about after a valid lawsuit, a valid claim, right? بأن تكون من خصم على خصم حاضر, that it must have been from somebody against the defendant who's also present. So all of those conditions should have been fulfilled, because if that's not the case, and the judgment given by, this is a very interesting point, that the judgment given by the person was not done with the formal procedure, then it's going to have a different hukm. So in this case, where there was something amiss, right, the judgment was given against the adversary, the defendant, who was not present, or the whole formal procedure was not followed properly, or whatever. لأنه إذا لم يكن كذلك يكون إفتاءً. Ya Allah. This is the first time he's produced this overlap and he's introduced the concept of ifta here. What that means is that if the proper procedure has not been followed, and for example the defendant was not present and he did it, he gave the judgment, the judge gave it against somebody who's not present, then that would merely be seen as a fatwa. Now remember, the difference between a fatwa and qada is that a fatwa is, I'll cover this more in detail in the next lesson inshallah, but a fatwa is not an official, well, you could have an official fatwa, but a fatwa is not binding. A fatwa is usually an opinion, whereas a judgment is a state, an implementable opinion by the state. A fatwa is an individual, it could be absolutely definitive and right, but ultimately it's just a voluntary opinion by somebody, and it could be completely right, but it's not imposable on anyone. It's only as good as people take it. I'll explain that more when we discuss that inshallah, but he says, yeah, that would just be an ifta because the proper procedure was not followed to make it an official judgment. فَيَحْكُمُ بِمَذْهَبِهِ لَا غَيْرٍ. And in that case, a person has to give a fatwa according to his madhab. He can't give a a judgment or a fatwa which will eventually, be which it will eventually turn out to be on anything other than his own madhab and his own position, right? This is as mentioned in Bahr. Anyway, then it says in الدر المختار وبه عرف أن تنافيذ زماننا لا تعتبر لترك ما ذكر. Ya Allah, very interesting. الدر المختار, Imam Haskafi, who is in 1000 and in just after the 1000 millennium of the Islamic, that's when he lived. He says that from this discussion we can understand that many of the judgments in our time cannot be considered, cannot be taken seriously, cannot be considered, because they usually abandon whatever procedures has been mentioned. Now, I don't know, I haven't done a study of exactly what the problems were of that time, but clearly he didn't have much trust in them. It seems that they're mostly fatwas rather than proper judgments. Okay, I guess if somebody did that and didn't follow full procedure, but the defendant accepted it and the claimant accepted it, and then the rights were established and there was a just decision that was given, then I guess it's done, right? It may not be seen as an official fatwa, but at least it helped people out. So I guess it's not all doom and gloom, right, in that sense. Okay, now there is an exception to this, right? In the case, this goes back to Quduri, where he said that if a prior judgment of another judge is then presented in front of a new judge, or a new judge, what can he do? He says, well, he can't do anything about it. He has to let it carry on. He says, إلا أن يخالف حكم الأول الكتابة, unless this first judgment that was made is clearly contradictory to the kitab, which means the book of Allah subhanahu wa ta'ala. Now, among those things in the book of Allah in which no Salaf, none of our pious predecessors had a difference of opinion about its interpretation, because there are verses in the Quran that could be read in two ways, that could have two different meanings. For example, the word qar'un, quru'un, can be referring to menstruation, but equally so, it can also refer to the purity period. And this is exactly what's happened between the Hanafis and Shafi'is, that one group has taken it to mean menstruation, the other group has taken it to mean the complete opposite of purity, and thus the hukm diverges in that case. So that is an open to interpretation verse in terms of its interpretation. But any verse in which there has not been any precedence of a difference of opinion from our predecessors, then in that case that judgment can be broken and can be negated by the new judge, right? The example he gives here, which is a bit strange, is كَمَتْرُوكِ التَّسْمِيَةِ عَمْدًا, like regarding the case of somebody who slaughters while purposely leaving out the Bismillah, which is the Shafi'i opinion that they still allow it. None of the other opinions allow it. So the editor has tried to clarify this. He says that Imam Aini has mentioned in his Binaya that what is intended here by going against the book of Allah, like a judgment that is clearly in contradiction to the book of Allah subhanahu wa ta'ala, it means that it opposes and contradicts the explicit text of the Quran, in which none of the Salaf have had a difference of opinion about. Like, for example, وَلَا تَنْكِحُوا, this one obviously is clear. وَلَا تَنْكِحُوا مَا نَكَحَ آبَاؤُكُمْ مِنَ النِّسَاءِ, do not marry any women that your fathers have married, which means your father, grandfather, whatever, anybody that they've been married to, even if they're not your mother, they're your stepmothers, you're not allowed to marry them, right, for however long they've been married to them. فإن السلف اتفقوا على عدم جواز تزوج امرأة الأب. The Salaf have all agreed on the impermissibility of marrying the father's wife. فلو حكم حاكم بجواز ذلك, so if there is a judge for some reason, he decided to say that that's permissible because it was for some close person to him, نقضه من دفع إليه. So if that judgment was presented to another judge to say, can you take a look at this? Because sometimes what would happen is that common folk may have a judgment and they're confused about it, or maybe they think it's wrong or whatever, so they take that judgment to another judge from one area to the other. So that's what this discussion seems to be all about. So in this case, if it was something that is clearly wrong like this, that goes against the Quran in that sense, then that second judge can annul that judgment, cancel that judgment, and give a new judgment in that regard. Right. Then our editor has a quote from Ibn al-Humam's Fathul Qadir, where he says that there is a difference of opinion that has been transmitted to us with regards to matruk al-tasmiyati amdan, which means that the animal on whom the Bismillah was missed out purposely, right, on the halalness of it. ففي الخلاصة عن رابع جنس من الفصل الرابع من أدب القضاء قال, so he quotes where he's taken this from. He says وأما القضاء بحل متروك التسمية عمدا, as far as a judgment with regards to the halalness, or it being halal, the consumption of that animal, that halal, that animal which has on which the during slaughter the Bismillah was missed out purposely. فَجَائِزٌ إِنْدَهُمَا وَعِنْدَ أَبِي يُوسُف لَا يَجُوزُ. So it would be permissible to give that judgment according to Imam Abu Hanif, meaning if a judge, a Hanafi judge shouldn't do that, but if a judge had given that judgment that yes, it's halal to still eat that animal, that is the Shafi opinion, by the way, right? Then according to Imam Yusuf, Imam Abu Hanifa and Imam Muhammad, that would be fine. They would say that yes, that judge has not given a completely invalid judgment, as they would say for the person who would say that it's allowed to marry your father's wife, right? According to Abu Yusuf, though he's strict about it, he says no, this should not be allowed. وقد قال بحل متروك التسمية عمدا من المذاهب الأربعة المعتمدة الشافعي. It's only the Shafis among the four madhabs who have allowed, right, people to consume, their followers to consume that animal on which Bismillah was left out on purpose. In the Hanafi school, if it was missed out by mistake, he forgot, he just quickly went and did it. Not that he remembered it, but you know what, I'm not going to do it. I'm just going to cut it. I'm a Muslim anyway, right? So that's what he's referring to. The Shafis, they allow it even if it was purposely forgiven. And it's also one transmission from Imam Ahmad ibn Hanbal. So now, in there's clearly some of the Salaf had a difference of opinion about this, but for some reason, Imam Maydani, the way he mentions it, he makes it sound like that is an example of something that the Salaf had no difference of opinion on. Okay, so unless he's referring to Salaf as only the Hanafi Imams, Wallahu Alam, but there's a bit of a confusion here. At least that's what I see it as. Okay, but I've given you an example of something that doesn't have a difference of opinion, which is marrying your father's wife. Then he says, أو السنة المشهورة, أو السنة المشهورة, or it contradicts a well-known sunnah, meaning a widespread, well-known something established from the sunnah of the Prophet ﷺ. For example, كالتحليل بلا وطئ لمخالفته حديث العسيلة المشهورة. Right, now this is an important discussion here. Like it being, right, so let me explain that if a woman is divorced thrice, then she, as Allah subhanahu wa ta'ala says, she cannot go back to her husband حتى تنكح زوجا غيره, until she does nikah with a new husband. So she has to literally get married again. Now the word here used is tankiha, which usually means just to marry. But because of, remember the hadith is what clarifies the Quran. And in a number of places the word nikah is used actually for consummation, for having sexual intercourse, right? Penetrative intercourse is what it's referring to. So pretty much everybody there's an ijma on this case, that the tankiha here refers to until she has sexual intercourse or consummates the marriage with a new husband. If she does that, then he divorces her, then she becomes neutralized again for the first husband. Of course, if they did this in a plan and pre-stipulated, that would be completely haram, and that's really, that's really cursed, right? However, if it's done incidentally, she got married to somebody and then they couldn't get along together, they had consummated, and then he divorced her, she becomes completely halal for her first husband again, right? So let's just say somebody gives a fatwa and goes against this and says it's enough just to marry someone, and once you're married he can divorce you, he doesn't have to consummate, and you'd be halal for your you'd be halal for your previous husband. That nobody give that fatwa. Okay, why? Because none of the Salaf did that. Okay, the overwhelming majority of the Salaf did not do that. There's only one Tabi'i who had that opinion, and everybody rejected it. Pretty much everybody else rejected it. Why? Because there's a hadith that makes it very clear what's going on here. That hadith is a hadith that Aisha radiallahu anha has reported. It's a sahih hadith in Bukhari, Muslim, and in a number of other places, that a woman came, actually the wife of Rifa'a al-Quradi, came to the Prophet sallallahu alaihi wasallam, and she said, so she had been divorced by her original husband. She had married this Rifa'a and wanted now to get away from him and wanted to go back to her husband, but Rifa'a would not divorce her. So she came to the Prophet ﷺ with an excuse, saying that كنت عند رفاعة. So she had been Rifa'a al-Quradi's wife, and he had divorced her thrice. So now she is not allowed to go back to him because it's banned now. They've had their 3 divorce options, right? And after that, you're not allowed to go, as Allah mentions in Surah Al-Baqarah. So she got married to somebody else, Abdurrahman ibn Zabir al-Quradi. So anyway, that's the story. She says that I used to be the wife of Rifa'a. He divorced me. فَبَتَّ طَلَاقِي. He gave me the final divorce, which means 3 divorces. فَتَزَوَّجْتُ عبد الرحمن ibn Zabir al-Quradi. I married him. وَإِنَّ, and she's basically saying that the poor man can't perform. وَإِنَّ مَا مَعَهُ مِثْلَ هُدْبَةِ الثَّوْبِ. The only thing that he has potential for, or his member, is just like the, like a hem of the garment. That's how soft it is, that he can't perform. فَتَبَسَّمَ رَسُولُ اللَّهِ صَلَّى اللَّهُ عَلَيْهِ وسلم. Prophet ﷺ smiled at her, her example. فَقَالَ أَتُرِيدِينَ أَن تَرْجِعِي إِلَى رِفَاعَةٍ. Do you really want to go back to Rifa'a, right? You want this new husband to divorce you so you can go back? La, you can't do that. حَتَّى تَذُوكِي عُسَيْلَتَهُ. Until you taste a bit of his honey. Usayla is said a small minute amount of his honey. وَيَذُوكُ عُسَيْلَتَكِ, and he can taste your honey, which essentially is a way of saying that you must have at least some kind of penetration. A consummation has to happen, otherwise you can't go back, right? So now pretty much everybody except I think one, Sa'id ibn al-Musayyib, his name is, right, the Tabi'i rahimahullah, he's the only one who said nikah is sufficient, consummation is not necessary, whereas everybody else, because of this sahih hadith, they've said that this is exactly how to understand this verse. So let's just say that, so the example he's providing here is that if there is a judge today or any time who gave the judgment that, oh, it's all right, you just married, you don't have to have consummation, go back. Now you're halal for your previous husband, that could be broken by another judge because that's completely wrong. And interestingly, I was just, I'm going to share this with you because we have a bit of time, right? I was just called a few days ago, a week ago maybe, a person who had this case. In fact, I spoke to him a few months ago, and then he called back and he said, look, regarding that case that we dealt with, I've come across a scholar who's writing a big paper on this, and he's taking this in a totally different way, and he's saying that this verse of the Quran says nikah, so we have to keep it in the meaning of nikah. The hadith there's only one hadith with regards to it, and that hadith has a special explanation, which is that the Prophet ﷺ only said that to her, that no, you have to basically consummate before you can be halal for your previous husband. the only reason he said that to her is because she was making an excuse, right? And he wasn't really like that, and she was just making an excuse, and the Prophet ﷺ knew it, so that's why he referred. But otherwise, really, we have to go with what the apparent literal meaning of the Quran is, and thus just marriage is sufficient. And this guy was very heated up and so on. And he told me that this particular scholar he spoke to said that, he's going to have 1,000 signatures on this from other scholars. I said, look, if he claims to be a Hanafi, okay, or any madhab, then what he's saying is completely against that. Look, we've got examples of it. So this person's a lay person, so he hasn't read the classical text. He said, is it mentioned from I said, it's mentioned all the way from the top imams, all the way down. There's never been another opinion on it, except Sa'id ibn Musayyib, which has been dismissed anyway. There's only been one person who had a different opinion. And this person is saying, no, that's the Sahih way. And then I had to explain to him that, no, this is something that is aberrant. It wouldn't be allowed. You can't go with that opinion, because if you did go with that opinion, according to all four schools of thought, according to pretty much everybody, non-madhab followers, Salafis, etc., they all agree on this point. That means this person would be, any woman who does that would be committing zina, because she wouldn't be halal for the first husband because she has no consummation. It'd make life so much easier though, right? It'd make life so much easier, because so many people would be willing to marry. They could even marry an absentee and never even seen one another. Just do nikah, get somebody, appoint somebody to be their wakil and just do nikah for them, and then immediately next moment give a talaq and done. Okay, you're clear for your husband now. Go ahead. In fact, why go that far? Why don't you just say that the 3 divorces he gave is equivalent to 1, as some people do? Like, why are you going so far? Anyway, that was just a side thing just to mention. But Imam Maydani mentions is very clear here that if somebody did give that fatwa, he gives that as an example of somebody going against the sunnah, because the hadith, the sunnah is, the hadith is very, very clear about this. Then the next judge could definitely break that, because it's the wrong judgment. Okay, so hopefully that's clear. Then he says, awil ijma', or a judgment is given by somebody against the ijma'. For example, they say that, hey, mut'a, temporary marriages are halal. There's an ijma' against temporary marriages. There was some issues about that in the earlier days, but then there was an ijma' made that no longer will temporary marriages be allowed. Okay, temporary marriage is when a couple say, okay, we're going to be married for 2 weeks, or we're going to be married to 2 hours. And there are people, Shia, they believe in this, and there are people who go around university campuses, getting married to girls temporarily, thinking it's halal just for, an overnight swing or whatever it is. Anyway, because the Sahaba pretty much agreed afterwards on the fasad and the invalidity of mut'a nikah. So if somebody does give a fatwa, then the judge can cancel that out. Or lastly, أو يكون قولا لا دليل عليه, or the opinion is not on a mujtahid fi issue, or it's regarding an issue in which, and it's a judgment that has no dalil, because usually they provide a reason for their judgment. كسقوط الدين بمضي السنين من غير مطالبة. Ya Allah, you go to the judge and you say to him that, what, I owed brother Musa £1,000, but you know what, it's been 10 years and he's never even asked me for it. It's been 20 years and even never even asked me for it. Judge says, you know what, that means it expired loan. It's expired, you don't have to pay him, which is completely incorrect. So issues like that, if they had given a fatwa like that with no understanding like that, similarly, it would probably be that, I haven't been with my husband, a woman says, for the last 5 years. We've never had any communication, but he hasn't divorced me. Has my nikah expired? And the guy goes, yes, it's expired. There's no such thing in the deen. So then another judge could break this. Okay, so alhamdulillah, to finish off this lesson for today, what we'll conclude this by is what I promised earlier, that we're going to discuss وَلَا يَقْضِي الْقَاضِي عَلَى غَائِبٍ, something that has been a recurring theme. I've mentioned it at least 3 or 4 times. He says no judge is allowed to make a judgment against somebody who is absent, who is not present, or their naib, their representative is not present. وَلَا لَهُ إِلَّا أَن يَهْضُرَ مَنْ يَقُومَ مَقَامَهُ, and neither to his benefit, unless it's done indirectly, but never to some, you can't make a judgment for the benefit of somebody directly unless it was done subordinately through another judgment, which I'll try to explain later, unless there's somebody to stand in for him, like his agent or somebody that he has put into his place, or ومتولي الوقف أو نائبه شرعا كوصي القاضي, or the judge has stipulated somebody to be in his place for a particular reason on a very important case. أو حكما, right? Now, this is a particular scenario where he says that sometimes, legally speaking, there could be something like that. That is an outcome of something. So, بأن يكون ما يدعي على الغائب سببا لما يدعى به على الحاضر كأن يدعي دارا في يد رجل ويبرهن عليه أنه اشترى الدار من فلان الغائب فحكم الحاكم به على ذي اليد الحاضر كان حكما على الغائب أيضا. There could be sometimes a subordinate, indirect judgment in favor or against somebody based on a judgment that took place because that person was a player. For example, a person claims to be entitled to a house that is in the hands of person B, and he provides evidence that he purchased that particular house from C. So this guy goes to court and says that I purchased this house, and he proves it that he purchased it from C, but person B is the one who has possession of it right now. So the judge makes a judgment against the person who's holding it on. Hey, give it over to this guy because clearly, look, he bought it from him yesterday, and here's the proof. How can he buy from him? And obviously, person B who's holding on to the house right now doesn't have any proof that he owns it. He just has keys and has possession of it right now, right? So when that judgment is made that yes, person A is the owner of it because he has proven that he's purchased it from person B, right? That is a judgment for person C, isn't it, as well? That it's originally his, right? Because if person A is proving that I bought it from Jabir, who is person C, Jabir is not around, right? Only person B is around, Musa is around, who's holding on to the house right now. But person A is established that I bought it from Jabir. So that essentially means it's a judgment that Jabir had sold it to him, in a sense, that he was the seller. So that's a indirect, it wasn't, that wasn't the purpose of it to establish him as the seller, but that is what subordinately became established because of person B, person A showing the proof that he did purchase it, right? And yeah, so there's a bit more detail in that, but that could, in some of those kind of cases, it could indirectly come about, but otherwise you're not allowed, a judge is not allowed to judge against anybody who's absent, right, directly for him or against him, right? So hopefully that's clear. That completes our lesson 14. We have a bit of stuff left regarding the individual, and inshallah we'll see you in the next lesson. Keep us in your du'as, keep White Thread in your du'as, keep Wise University in your du'as. Assalamu alaikum wa rahmatullah.